Okay, so today we're going to look at civil pretrial procedures in the Supreme Court from Unit 4, Area Study 2. The study design sets out that you need to know Supreme Court civil pretrial procedures, including pleadings, discovery, and directions hearings, and the purposes of those procedures. So you need to know all three specifically: pleadings, discovery, and directions hearings. You could be asked specific questions about their purposes or any of the stages of those civil pretrial procedures. Just generally for pretrial procedures, the main aim is to inform both parties and the court of any information relating to the case. They attempt to negotiate an out-of-court settlement if possible. They also try to avoid the time and expense of going to court, and that if they do go to court, that all the information that is provided in the pretrial procedures hopefully should result in a quicker trial. So you try to avoid the trial if possible, because it takes a lot of time and it's expensive, but also if you do that, any information you gain should actually speed up the trial itself and save you time and money there. Firstly, for pleadings, the purpose of pleadings really is to gain information about the claim. They require the parties to state the main issues of the case and compel each party to state the material facts. They give the court a written record of the case, and they save the court time and expense. And also, they should help to assist an out-of-court settlement if possible. As the parties learn about each other's case, then one of them may decide to settle. The pleadings contain details of the claim by the plaintiff and any matters being raised as a defence by the defendant. They include four main documents: the writ, notice of appearance, a statement of claim, and a statement of defence. Firstly, the writ is just a formal written document. That's where the name comes from, a written document. The plaintiff issues the writ against the defendant, which explains the action being taken against them and informs them in which court the trial will take place and whether there will be a jury involved. The writ is then sent to court and a copy served on the defendant by the plaintiff. It sets out the cause of action and the remedies sought. So what they're suing for and what actual remedy they're seeking. So they might be suing for negligence or defamation. They might be seeking damages of a particular amount of money, or they could look for it to get an injunction or something else. The filing of a writ is actually the commencement of legal proceedings. It's the formal start of legal proceedings. We then move to a notice of appearance, where the defendant, once the writ has been issued, the defendant is required to enter a notice of appearance that indicates whether they will defend the case against them. The statement of claim is normally attached to the writ by the plaintiff. It just explains the nature of the claim, explains the cause of the claim, and it sets out the remedy or the relief that they're seeking in the claim. And finally, the statement of defence, the defendant will just set out a response to each of the allegations contained in the plaintiff's statement of claim. So if they're suing for defamation, they may set out that they will be using truth as their main defence. Normally it either admits or denies the allegations. So either admits to them and will look to settle, or they deny the allegations and indicate that they're going to be defending them at court. And that's it for the pleadings. In terms of the discovery stage, the purpose here is to allow the parties to get further information about the facts of the case. Okay, so just comparing discovery and pleadings, the pleadings really is to gain information about the claim, what the plaintiff is suing for, the remedies they're seeking, and what the defendant will be raising in defence. Discovery is about gaining details about the facts of the case, so what actually occurred. It helps the parties prepare their cases and hopefully will save time at trial and reduces the element of surprise as well. There's three main stages: the interrogatories, the discovery of documents, and medical examination and reports. Firstly, interrogatories. Either side is able to serve interrogatories on the other. They're essentially questions relating to the known facts of the case. Interrogatories reminds me of the word interrogate. They're just questions about the facts of the case that are designed to obtain information that either party can use as evidence. There's generally a deadline set for written responses, and if you want, you can also depose witnesses, but hopefully if it's done in written responses, that will save time and money as well. that saves court time and expense because you don't have to question every single witness at trial. You can just identify the key issues in the case, the key facts of the case that need to be contested at trial, and just focus on them. They deal with the matters before the trial, and it also reduces the element of surprise so that each party can best prepare their case. So each party has an equal chance of preparing their best case. Discovery of documents. Either side can just request the other side to disclose any relevant documents, and both sides must disclose all relevant documents to the case. So either party is allowed to inspect all relevant documents. Some documents can be protected by privilege, either doctor-patient or lawyer-client privilege. Their existence must still be disclosed. Finally, medical examination. So obviously a lot of civil cases involve bodily injury. If there is injury, then the defendant can ask the plaintiff to submit to appropriate medical examination to determine the extent of their injuries. They can also ask for hospital and medical reports to be produced that detail what injuries were sustained by the plaintiff. Directions hearings, the third civil pretrial procedure that you must know that's listed specifically in the study design. Essentially, the court in a directions hearing just gives directions to the parties as to the conduct of the case, so how the case will proceed. They could set out how the discovery stage should run, how long will be given for interrogatories, discovery of documents, etc., and how long the trial should take. Their aim really is to assist an effective, complete, prompt, and economical determination of the case. They encourage the parties to make admissions that will speed up the proceedings, so if both parties agree to certain facts, they don't need to be raised at trial, they can just focus on the issues that count. Also, the judge can rule on points of law during a directions hearing that may save time. It may also lead to an out-of-court settlement. They can also refer the matter to mediation or arbitration. And finally, mediation itself is now a more important civil pretrial procedure, and particularly given the emphasis on dispute resolution in the last area of study. It's just good to know that the Supreme Court rules now state that at any time during pretrial or trial proceedings, the court can order the matter to be referred to mediation. And the majority of the time, the court now orders parties to attend mediation before the trial in order to try to promote an out-of-court settlement if they can, and also to identify issues, the main issues in question, so that they can save time at trial. And that's it.